welcome you again, particularly the winning competitors, and Anna, Ignacio, and Priscilla, and Filene, and Katerina from UNIDROIT. This competition, the 2025 essay competition, was based on this is the 10th anniversary of the UNIDROIT Legal Guide on Contract Farming. The essay competition is always given by UNIDROIT, supported by the UNIDROIT Foundation and International Law Institute. This has been a special year. We've had I think Katerina told me 185 papers were submitted, including for the first time in a language other than the King's English, namely French. And I gather I think one of the winners will actually speak in French. So now I think I'm done, and I turn things over to Anna to proceed. So thank you.
Thank you so much, Don, Professor Wallace, for your opening remarks. And in particular, many thanks to the International Law Institute for your continued and generous support to the UNIDROIT Essay Competition, which would not exist without you. So thank you very much. And congratulations. Congratulations to the 5 winners of this year's competition. Well done. Very happy to see most of you online. Now, as Don already said, we received 185 submissions, a record this time, and our winners come from very different parts of the world, from Malawi, Indonesia, Uganda, Senegal, and Australia. And this illustrates the global interest in the topic and in the agricultural law. Now, Professor Wallace already said that this essay competition is dedicated to the 10th anniversary of the UNIDROIT FAO IFAD Legal Guide on Contract Farming. This is particularly close to my heart, if I may, also because I had the honor many years ago to contribute to its development on behalf of UNIDROIT. Now, we know that contract farming is a common contractual arrangement around the world, and it's promoted as a way to achieve more stability of output and prices, food security, and a more cooperative production model. Its benefits, however, are directly linked, among others, to the way the contracts are drafted and implemented. And the legal guide is a soft law instrument offering guidance on fair and effective contractual terms for contract farming arrangements. It provides advice on the entire contract relationship, common contractual terms, a discussion on and problems under a variety of practical situations. So if you allow me, I know that you're all waiting for the presentations and the discussion of the winners' contributions, but allow me to very briefly place this guide in the context of UNIDROIT's work stream on private law and agriculture, which exists since 2010 with its inclusion in the work program of the Institute by the General Assembly. And it's important to recognize, I think, that private law can play a fundamental role together with the public and regulatory legal environment to attain the goals of sustainable agricultural development and food security. And the publication of the legal guide on contract farming, which was in 2015, is particularly relevant also because it marked the concrete beginning of the very fruitful cooperation with FAO and IFAD, the UN agency based in Rome. And this cooperation continues in the implementation of the guide with additional useful practical instruments. It also continued with the publication of another legal guide, the Agricultural Land Investment Contracts Legal Guide, and currently a new legal guide on collaborative legal structures for agricultural enterprises is being developed, which addresses challenges and opportunities of different legal forms. It also looks at how technology, in particular platforms, can contribute to this development, and the winners also touched upon some of those issues. I would like to acknowledge the presence here of my colleague, legal officer Priscilla Andrade, who is in charge of this project. But UNIDROIT's work touching upon private law in agriculture is not limited to these 3 legal guides. It encompasses also other topics, importantly, the financing of agricultural production. Let me just mention a treaty, the Mining, Agriculture and Construction Protocol to the Cape Town Convention, to facilitate the acquisition and use, among others, of high-value agricultural equipment, which can be a game changer for many jurisdictions where this sector plays an essential role, but also a soft law instrument, a model law. More recently, in collaboration with Ancestral, UNIDROIT has developed a model law on warehouse receipts, which is guide to enactment to facilitate access to credit, especially for smallholders and small and medium-sized enterprises in the agricultural sector. And here I acknowledge also the presence of legal officer Wheeling, who was in charge of this project. So now we come back finally to the topic at hand, which is the contract farming. And before introducing the winners, I would like to conclude with 3 short observations, if I may. The first one, I would like to go back to what Professor Wallace said about the linguistic inclusion, because this year, for the first time, we accepted essays in both English and French. And we do have participation of Monsieur Samir Zime Yerima from Senegal, who will speak in French today. So thank you very much. Secondly, I would like to extend my heartfelt thanks to all the colleagues at UNIDROIT who contributed to the organization of the essay competition and the selection of the winners. And if I may single out in particular Katerina Bovsunowska for her excellent coordination also this year. Thank you very much. And finally, all of you, you have 7 minutes to present the core of your topic, and then we will discuss it also with those who very kindly are present online in the webinar. So allow me then, if I may, Katerina and Don, to shift to the first position, the winner of the competition in the first position, who is Andrew Umali, and he is a Malawian legal practitioner and law scholar, currently pursuing dual postgraduate qualifications in Rome and at Liverpool John Moores University. He is also admitted to practice law before the courts of the Republic of Malawi. His main research interests are in technology, market regulation, intellectual property, and the role of harmonization in fostering sustainable economic development. And by chance, because the 2 selection process were completely distinct, but he has also been selected as an intern to support the project on legal structures for agricultural enterprises next year. So his presentation has the following title: From Soft Law to Field Realities, Examining the Influence of the UNIDROIT FAO IFAD Contract Farming Guide in Malawi's sugarcane sector. So, Andrew, if I may, you have the floor for your 7 minutes.
Are you able to see the slide? Okay, perfect.
Yes, we are. Yes, thank you.
Okay, so my name is Andrew Umali, as introduced by Professor Veneziano. Before I begin, I would like to express my sincere gratitude to UNIDROIT and the International Law Institute for convening this platform and for affording us the opportunity to present our work before, among others, the very architects of this instrument. This is an opportunity that I personally don't take for granted. So my paper is entitled From Soft Law to field realities, examining the influence of the UNIDROIT, FAO, IFAD, contract farming legal guide in Malawi's sugarcane sector. So for decades, Malawi's contract farming framework was so generic that a sugarcane supply contract between a multinational agribusiness such as Irovo Sugar, whose annual turnover reached 13.1 billion in the 2024-2025 fiscal year, and a smallholder farmer in Malawi was legally treated as a meeting of minds between parties that have equal bargaining power. So in essence, courts would interpret any agreements as entered into between freely negotiating parties and that they are on equal terms. But in practice, smallholder farmers had little to no legal recourse in cases of late payments, arbitrary cane rejection, or unfair deductions under input credit schemes. So this has been the case for a very long time. Of course, there were discussions from 2007 onwards, trying to find a solution to some of the injustices that were there. And luckily, some of these developments coincided with the fact that the legal guide by UNIDROIT, FAO, and IFAD came in 2015. So the guide itself offered some best practices aimed at promoting fairness, transparency, sustainability within these contract farming relationships. So my paper basically argues that the guide itself achieved something more profound than a simple articulation of these best practices. Within Malawi's sector, it has functioned as more of a normative transplant, a catalyst that has basically disrupted and shattered the status quo in relation to contracting as it was pre-2015. So yes, as you can see on the next slide, pre-2015 there was what I term a regulatory vacuum. Of course, the term regulatory vacuum should be understood loosely, because yes, general principles of contract were still at play, but they were not as functional as they should be in dealing with the issues that were at play. And the coming in of the guide in 2015 basically acted as a catalyst to a normative North Star, because as policymakers were sitting down soon after this guide came into being, and as are developing the national contracting policy, they are basically pointing to the guide as an indicator of the international best practices. So most of the things that are indicated in the guide, most of the principles have then been included in the policy and in what has been advanced since 2016, basically. And from 2024 onwards, the Competition and Fair Trading Act was amended, and it recognized contract farming terms as reviewable by the Competition and Fair Trading Commission, and so that any inclusion of unfair contract terms within contract farming agreements, the same would be treated as an unfair contract, as unfair trading practices, and then public law would be coming in, and the commission would be coming in imposing sanctions and something and things that are even sanctions that are even greater beyond the dictates of the contract itself. So looking at the fact that most of these farmers, and you look at the bargaining power of the bargaining power itself, they're on the lower side. This comes in to bring about an equalization in some way. Also, in 2025, we have seen the passing of the Sugarcane Industry Act, which has set up a special tribunal that deals with any matters that are arising from the relationship between millers and outgrowers or smallholder farmers, and also issues to do with pricing formulas and the like. They have also been placed within the mandate of the commission that needs to be established under the Sugarcane Industry Act. So in terms of the general outlook of the reforms that have been in play, there's been a shift from verbal promises to mandatory written agreements, which means this is something that can easily be evidenced. Issues of risk allocation are now supposed to be included and properly addressed within the contracts. And this is really important, especially for Malawi, because most of the sugarcane production occurs within the Great African Rift Valley. So whenever there is flooding, and which is something that occurs every now and then under the old regime, it will be the farmer who has breached the obligation to make the supply. But now, for example, in 2020, there was flooding, there was Cyclone Freddy. We have noticed a shift where even banks would come in and facilitate loan rescheduling. We would find out that even a company like Ilovo would come in to let's say, cushion any losses that farmers have incurred within that system. The issue of competition is something that I've already addressed. Issues of the protection of the environment and child labor have also been specifically outlined as non-derogable within this contractual framework. So if, let's say, an outgrower scheme is found to incorporate children within its labor force, then that can be a ground for the termination of an agreement with a company like Ilovo, which is something that is so progressive and in line with the dictates of the guide itself. In terms of some success stories, the cardinal objective of the contract farming guide was to basically enhance the inclusion of smallholder farmers in profitable value chains, such as sugar production in this case. And in Malawi sugarcane sector, this objective is being increasingly reflected in practice. Pre-2015, 2014, 2013, sugar production by smallholder farmers, outgrowers, was around 8 to 9%. But in 2025, close to 45% of sugar is now produced by smallholder outgrowers. Even looking at the incomes that go directly to farmers, research shows that there's been an increase of 38% for participating smallholder farmers when compared to farmers that are not participating in the contract farming system. Also, there's been high formalization, as I already indicated. Most of the contracts now have gone beyond verbal promises to proper written agreements, and this has also fostered investment. Banks are more open to put up loans to farmers, knowing that they're dealing with farmers that already have a market through contracting and as guided by the principles that were outlined in the guide. Lastly, it's also important to point out that there is still room for improvement. As Professor Veneziano indicated, UNIDROIT is also working on another instrument on collaborative legal structures for agri-enterprises, and I think that will be crucial in dealing with the issue of exclusion. As it stands, the scheme literally favors asset-rich farmers who have land, who have capital. The poorest of farmers are still structurally excluded. And I think with the coming in of this new instrument, most of the issues that are rising now, or the exclusion that is existent at the moment, may be addressed. There are also issues to do with access to justice. Although a contract may be written well, it's still a paper tiger without proper legal aid, without access to courts, and this is still something that is a big issue in Malawi. Of course, steps are being taken with the coming in of a proper legal aid structure within the country, but still, challenges still remain. There are also issues to do with transparency, in particular on the issue of pricing. But now I think with the coming in of the Sugarcane Industry Act, and with the mandate being brought to a commission within or formulated under that act, maybe issues of pricing and the differences that are still in existence may be addressed. But it will still be exciting to see how that will be implemented as the act has just been passed, and institutions that are supposed to support this act are yet to be rolled out. Otherwise, thank you very much. My time should be up. I just want to say thank you very much for your attention.
Thank you. Thank you very, very much, Andrew, for your presentation. You went a bit beyond the time, but I understand the difficulty in keeping within the limited time. But let's ask Caterina, did you envisage that we would have perhaps 1 or 2 questions after each presentation? We don't want to take all the time for the first one and not leave sufficient time for the others, but perhaps 1 question at least or comment.
Of course, 1 question or comment we could accommodate.
So may I open the floor to that? And Caterina, let me know whether there are any comments from the webinar participants as well. So any questions or comments on this first presentation?
Anna, may I ask a question of Andrew?
Of course.
When he comes to Rome on his internship, I don't remember what you said, but would he be able to work on some of the practical issues of how you implement the contract, the guide, as Andrew suggested, various structural defects, etc.? Is there anything he can work on when he's in Rome to make it more likely that the guide and the contracts that result will have a greater effect on the benefit, for the benefit of the farmer?
So perhaps I can answer that he has been selected to work on the collaborative structure for agricultural enterprises, but some of the issues he raised are actually treated within that project, and of course interns can always share their experience, and now that we know that he has this experience, it would be great to have him more actively participate in that. But I see that Caterina, you wanted the floor.
I didn't want to interrupt you, but we have 1 question in questions and answers section. Would you like me to pronounce the question? Yes? Okay, so we have 1 question from Isibor or Kenan. Apologies if I pronounced it wrongly. And the question goes as follows. What are the key legal and economic challenges in contract farming arrangements, and how can both smallholder farmers and agribusinesses mitigate risks while ensuring fair and sustainable partnerships? I believe it's a very broad and serious question, maybe the core question of today's webinar, but perhaps Andrew could share his perspectives on this.
Okay, I think the issue that comes to mind immediately is risk allocation. As I was making the presentation, I highlighted that in 2020, for example, Malawi experienced a devastating flood, Cyclone Freddy. So basically the water destroyed most of the areas where sugarcane production happens. Now, in this scenario, this is a huge loss, not only for the industry, but for the farmers and for the agribusinesses themselves. Now, in order to mitigate this, you notice that within the agreements that were entered into between Illovo Sugar, for example, and most of the farmers, there are arrangements to ensure for any loss that would come in. So force majeure clauses were very crucial, plus putting up measures, because this is a big company. Insurance companies are more open to step in and to provide an insurance to provide cover in such scenarios, which is something that is very important, and an arrangement which is crucial. But still, even from a contractual perspective, the principles relating to risk allocation that are in the guide become crucial as well, because the loss doesn't come to the farmer alone. It is something that is shared, because then the benefits are also shared. So those are some of the ideas that I have on the point on the fly. Thank you.
Thank you very much. Perhaps we can then move to the other presentations. There are other questions online, but perhaps we can leave 10 minutes at the end so that even the other participants in the competition might chime in with their ideas on the questions that were asked. So allow me to get to the second position.
If I may jump in, I see that Patricia, she got offline, unfortunately, from the webinar. So if we could move forward with...
Yes, I just wanted to say that
Patricia reconnected.
Yes, I just wanted to say that the winner of the second position, Muhammad Nur Fitrianshiha from Indonesia, cannot be present today. And his title was Digitization of Equitable Agricultural Contracts through the Implementation of the UNIDROIT Principles in Indonesia's Farmer Ecosystem. So this is to acknowledge his participation, but he cannot be with us today. And we hope then to hear now from Patricia, who got the third position. So Patricia, Ayerango Patricia, holds a degree in business administration with focus on accounting and finance from Makerere University Business School in Uganda, drawing on her upbringing on a smallholder farm in Uganda. Her work focuses on analyzing how economic and commercial decisions affect sustainable development, particularly in agriculture, and her primary goal is to leverage economic analysis to drive sustainable and equitable agricultural policy with a focus on smallholder farmers in East Africa. So, Patricia, your title is A Decade of the UNIDROIT FAO IFAD Legal Guide on Contract Farming, Prospects for Equitable Agriculture and Sustainable Livelihoods for Smallholder Farmers in Uganda's Coffee Sector. And you have the floor for your 7 minutes, hoping that the connection works. Can you hear Patricia? We cannot hear you, Patricia. Oh, okay.
Hello, everyone. Can you hear me?
A bit faintly, but we can hear you. Perhaps you can try to fix. Yes, a bit better. Thank you.
Okay, so you can see my screen?
We can see your screen. Yes, it's a long screen.
Okay. That's it. Okay, so hello, everyone. I've already introduced. My name is Patricia, and I won third place. So before I start my presentation, I'd like to first thank UNIDROIT for this opportunity to present here and to present my essay. And I'd also like to congratulate all the other winners. And so my essay posed a question on, not really a question, but it was analyzing whether the legal guide, whether there are any prospects for smallholder farmers in Uganda, and specifically the coffee sector. And so the reason why I picked the coffee sector was because, first of all, it is the largest agricultural sector in Uganda. We are more of an agricultural country, and so coffee represents the biggest return when it comes to agriculture. So I picked coffee because, first of all, it directly supports 1.8 million smallholder farmers. That's a lot of people. And also, whatever impact, whether positive or negative, the legal guide can have, if we can apply it to the coffee sector, then it's easier to move all these other, like to analyze that and then apply to the other agriculture sectors. And so
So
I focused
I'm sorry, Patricia. Is there any way you can improve a little bit the sound of your presentation, because it's difficult to follow what you're saying from I don't know if all participants have the same problem or just a couple of us.
What about now?
This is much better. Thank you, Patricia.
Better?
This is the way to go. Thank you so
Thank you.
much.
Okay, so yeah, I was on my second slide. Sorry, yes, I was on the third slide, and I was trying to answer the question on, basically I was trying to communicate the three critical gaps that should, because in Uganda, the coffee sector and most of the agriculture sector, I think our contract business when it comes to farming, it's mostly generic. And a lot of smallholder farmers don't really get access to legal advice or anything like that. They usually just go with generic templates or make informal contracts. So the legal guide is not fully embraced in Uganda like it is elsewhere. So should it be embraced? I pointed out three critical gaps that it would help close for the coffee sector itself. And the first one is land tenure and stability. We have a lot of wrangles when it comes to land, and especially smallholder farmers are mostly affected. People who run large businesses in the coffee sector don't usually get the same problem. But when it comes to smallholder farmers, there is a lot of land wrangles and they don't get as much help. So the legal guide, it offers a way to help these guys, the smallholder farmers. It has some provisions, it's chapter 1, that help for land, like that they provide for how smallholder farmers might be able to hold on to their land or might be able to go into contracts knowing what to do should they face a problem of land, like land wrangles. And then my second point was policy and information equity. This one mostly I talked about the knowledge they can get because, like I mentioned, the informal sector, which is where smallholder farmers are mostly are, they don't get to have resources. They don't get legal resources. Most of them don't even know some legal ramifications. They may not know if I enter a contract, what do I need? What are the other partners? What are their obligations? They may not know those things. They just enter contracts, and if anything goes wrong, they are the ones to face the consequences. But if they embrace the legal guide, or if it's communicated that the legal guide could help them, then it would be a very critical tool in policy and information equity. They would get to know contract terms. They would get, like I said, the land. It would help them with any wrangles arising according to land. The legal guide helps accessing input. It helps on making contracts that would help them access better inputs instead of getting coffee, when it comes to the coffee sector anyway, instead of getting coffee seeds, mostly contracts for coffee seeds, fertilizers, things like that, you enter into a contract with a supplier and you know they're going to supply something that is good rather than doing an informal thing where you're not sure. So the legal guide could help on that, and especially inputs and contracts with suppliers from in and outside the country. And the last one is value chains and input access. I touched on input access, but value chains is important because smallholder farmers usually just produce the coffee and sell it. They don't get to process, they get to sell, but because they're informal, they don't get to benefit from the price point. It's different for them, like it is for their larger counterparts. So the legal guide could help include them or could help facilitate their inclusion into the critical value chains. They could produce coffee that could be easily processed without suffering the consequences of pricing, like when they're underpriced. And then I touched on the implementation challenge where I talked about the accessibility gap. Because I'm talking about informal sector and smallholder farmers, you realize that most of these people do not have legal education or don't have a legal background. And even if they don't, they cannot access legal resources to help them. So if they can just access this legal guide, it could help them. But the legal guide is in English, and with the informal sector is not as educated. So my solution for this was the legal guide could be translated into local languages so that these people can access it. So one of the major implementation challenges would be the accessibility gap in terms of language barrier, and also interpreting the legal language so that the everyday person can understand it. My second hurdle was policy misalignment. And this is important because the EU passed a law, the deforestation law, if you're familiar with it. And a lot of our farmers here in Uganda don't know anything about that. They're not that informed. So if, as Uganda, as a country, if we could somehow liaise or get to the EU and communicate what we, okay, what I'm trying to say is the EU has its own rules, like the deforestation law that they just passed, but that it may not be in line with the legal guide. So what we need is to communicate, to sort of align, so that if the legal guide is very helpful to our smallholder farmers, then maybe the same guide could be somehow translated into the EU laws, so that whatever happens here somehow connects to what happens there, to make it easy for farmers to export coffee to the EU without having to suffer the consequences of the law, such as the deforestation law that was passed. And yes, I think that was it. That was it for me.
Thank you.
The guide is needed, but there are some challenges that we shall face. But I believe they can be closed off. So thank you, everyone.
Thank you. Thank you very much, Patricia, for your presentation. And if very happy to receive comments or questions, at least one or two, before going to the next presentation. Katerina, can you see whether there are any comments or questions online?
Yes, we have another question from Isibor, who is actually also our active alumni of UNIDROIT, about the cocoa processing company in Ghana. And I'm wondering if he would like to ask this question himself by voice. Would that be a good idea?
Yes, no problems at all on my side. But it must be very short, please, Isibor. You understand that we have to proceed also with the other presentation. So short question or
Thank you
comment.
so much. Yeah, my question is, how can contract farming agreements within the cocoa value chain be designed to balance equitable benefits between smallholder farmers and agri businesses, while promoting sustainability, fair price, and risk sharing as well? Then also we need to look at value addition through the chain. So I don't know, whatever way he can explain or she can explain is fine. Whoever wants to take it. I don't know if Professor Wallace will want to weigh in on this as well. Thank you.
Thank you. Thank you very much. So perhaps, Patricia, again, this is a very general question, but perhaps you can tailor it to the presentation that you have made, and particularly the sector you are most familiar with, Patricia.
Okay, so for me, I talked in the coffee sector, and I'm going to touch on maybe the value chains. I believe the question is how the legal guide can facilitate inclusion into the value chains. If that's the question, that's what I'll explain. For me, from my research, legal guide facilitates contracts with suppliers, especially for smallholder farmers who may not access quality products because they may not enter into contracts that help facilitate that. So the legal guide could facilitate implementation of contractual relations with suppliers who supply quality products. And if you have quality products, then it's easier for the people who buy your coffee, who buy processed coffee, who buy your coffee for processing. It's easier for them to buy from you because they trust your output than if they don't, because you did not engage with suppliers. So the legal guide facilitates that because it makes sure the contracts you make with suppliers, they have an obligation to supply quality products. I think from my angle, that's how I understand it.
Thank you. Thank you, Patricia. We do have, Katerina, another question by Professor Panneback, Katerina, who congratulates the winners, but has a question which was, I must say, the same question I would have had, which is how exactly the deforestation legislation would impede the implementation of the legal guide. That's also quite a difficult question to answer in short, but the idea is the legal guide is so what would be your first answer to that, Patricia?
Okay, because the EU, the deforestation law, I believe in full, it's mostly about to prevent whatever imports are coming into the EU shouldn't be because they were grown on land where deforestation was carried out, right? Now, from my angle, what I was the way I brought it in is our farmers here in Uganda don't know that, or they may not have the knowledge that the EU passed such a law. So the way the legal guide, the way I was talking about it was, if we can align, if the EU could align its I want to say proposals with the legal guide, because here in Uganda, if we adopt the legal guide and the EU aligns its proposals with the legal guide, it would be a seamless translation. So the deforestation law came in because I was trying to, it was like a challenge. The EU passes its laws and we can't do anything back here because we have no choice but to follow the EU. But if the EU has the same, we're on the same page, then maybe it will be easier and seamless to import our products, and the legal guide could facilitate that if the EU could integrate it into their laws. And so back here, we can just follow the same laws because they are integrated into the legal guide. Does that answer this question?
Thank you, Patricia. I think Jeanette Tramel had exactly the same question. I think this would entail a much longer discussion because the acts are very different. One is a legislation and it's mostly geared to deforestation, while the other one is a contractual guide which actually takes into account public mandatory rules which might exist in the different parts of the world where the two parties come from, but it also integrates a system of communication and information about elements that are important for example, the producer to know. Usually this is the transparency of what is required is the most important element to consider. But I would leave it open because it's a very interesting point, also more generally, and I would perhaps, if there is time afterwards, go back to this issue. But allow me then to turn to the quatrième position parce que Samir Zime Yerima va parler en français. Il est attaché temporaire de recherche et d'enseignement à l'École des droits de la Sorbonne. Il enseigne le droit international public et les relations internationales et il est aussi doctorant en droit public, titulaire de plusieurs diplômes d'études avancées en droit public, international, droit africain, droit de l'énergie et arbitrage international. Et il a aussi reçu plusieurs distinctions, dont les prix Guy Carcassonne. Et il va parler sur les sons et la portée du guide juridique sur l'agriculture contractuelle dans un contexte de pluralisme juridique, les cas des pays d'Afrique subsaharienne, c'est-à-dire une vision comparative. So very quickly, he's a junior lecturer at the Sorbonne Law School. He teaches public international law, international relations, and a PhD candidate in public law. He holds multiple advanced degrees and received several distinctions, including the Guy Carcassonne Prize. And so, vous avez la parole. Merci beaucoup pour 7 minutes pour vous. Merci.
Merci beaucoup, Madame la professeure. Hi, everyone. My name is Samir Zime Yerima, and I'm very happy to be here with you. And I feel also very privileged to speak in French. Donc, je vous le disais tantôt, c'est un plaisir singulier pour moi qui se double de l'honneur de m'exprimer en français pour cette année. Et donc, ma communication porte sur le sens et la portée du guide juridique UNIDROIT sur l'agriculture contractuelle. Un petit élément de contexte, c'est d'abord le contexte géographique. L'Afrique subsaharienne, une zone géographique plutôt large, hein, c'est quand même environ 48 pays, avec des différences cependant qui ont un certain nombre de points communs du point de vue de leur traduction juridique, du point de vue surtout de ce que j'ai nommé le pluralisme juridique. Et s'agissant de cette agriculture dont nous parlons, elle se caractérise dans ces pays-là essentiellement par la présence des exploitations familiales, une agriculture majoritairement rurale, et également la prédominance des contrats souvent informels, oraux, et qui s'accompagnent également de la présence de beaucoup de règles coutumières. Et donc, dans ces pays, il y a également une caractéristique, c'est que parfois, c'est la Constitution elle-même qui va même jusqu'à reconnaître la présence de règles coutumières auxquelles il faudra donc s'intéresser. Et donc, du point de vue personnel, notre contexte, c'est que, venant d'un milieu rural moi aussi, je me suis dit, mais finalement, quelle peut être la portée, la pertinence d'un guide comme le guide UNIDROIT sur l'agriculture contractuelle dans un pays où il existe cette pluralité, cette cohabitation de normes, où il y a une prégnance également de pratiques informelles. Et c'est donc à cette question que j'ai essayé de répondre dans le cadre de ma communication. Et en analysant le guide, le premier résultat ou la première réponse qui m'est immédiatement venue, c'est que le guide ne méconnaît pas le pluralisme juridique. Au contraire, il le reconnaît et il le définit, même si voilà, sa définition peut parfois être sujette à controverse ou critique, mais elle reconnaît quand même le pluralisme juridique et le définit comme le droit de certaines régions ou communautés à être régies par des règles spécifiques reposant sur la traduction juridique ou des critères personnels, ethniques, territoriaux ou religieux. Et le guide va plus loin. Il va plus loin parce qu'il fait preuve même d'un certain réalisme, car il va jusqu'à reconnaître que dans certaines situations, des règles informelles, des pratiques locales, coutumières, peuvent même prévaloir sur le droit écrit. Or, pour qui a un tout petit peu pratiqué les droits africains ou de la manière dont les conventions, les contentieux se règlent dans certains pays africains, on se rend compte qu'à vrai dire, finalement, c'est la pratique qui prend le dessus sur le droit écrit. D'un autre côté, je me suis rendu compte que le guide va jusqu'à intégrer des usages coutumiers, des usages informels dans l'encadrement du contrat lui-même. Et plusieurs éléments pour le relever. D'abord, s'agissant des parties, le guide reconnaît des communautés locales, autochtones. C'est-à-dire pas nécessaire à la personnalité telle qu'on dans les traditions civilistes, les organiques qui ne répondent pas nécessairement au schéma classique de la formalité juridique. Le guide reconnaît que ces différentes entités peuvent tout à fait être également partie dans le cadre de ces contrats-là en tant que producteur. Il en est également des populations autochtones. S'agissant de la forme des contrats, et c'est ici un aspect essentiel, le guide va reconnaître également que le contrat n'est pas nécessairement le contrat écrit, formel, tel qu'on a l'habitude de le croiser, mais que une simple poignée de main peut également être bel et bien constitutif d'un contrat. Nous verrons plus tard que le guide ne se limite pas là et il va dans ce genre d'hypothèse proposer des moyens pour quand même sécuriser ce genre de contrat. Et c'est d'ailleurs là toute son utilité. Ainsi, s'agissant par exemple de ces contrats informels, tout en admettant que le contrat peut être verbal, peut se conclure par une simple poignée de main, il recommande des moyens pour le sécuriser. Il exige par exemple la présence d'un tiers impartial. Et comme caractéristique de ce tiers, il exige que le tiers ne soit pas lié d'une manière ou d'une autre à l'activité contractuelle, qu'il n'ait pas un intérêt économique dans le cadre du contrat qui est conclu. Bien. Finalement, même du point de vue de la résolution des différends, et là, c'est j'ai envie de dire un bien commun de la pratique juridique de plusieurs pays africains. Les solutions que le guide propose, qui ne sont pas des solutions judiciaires, c'est-à-dire qui ne nécessitent pas nécessairement l'intervention d'un juge étatique, elle cite la médiation, la conciliation, et ça nous rappelle ici un certain nombre de pratiques bien connues des États africains et des agriculteurs locaux qui consistent en la palabre, c'est-à-dire que dans le cas d'un contentieux entre un producteur et son concurrent, au lieu d'aller directement vers le juge, au lieu d'aller directement vers la résolution judiciaire du différend, on essaie de faire intervenir un tiers qui n'est pas nécessairement juriste, mais qui a l'aptitude et la compétence pour amener les différentes parties au contentieux à résoudre le différend sans nécessairement passer par la case de la justice. Et donc, finalement, j'en viens à cette conclusion pour dire que le guide juridique sur l'agriculture contractuelle est l'archétype finalement de l'instrument de soft law. L'instrument de soft law qui a vocation à s'adapter quel que soit le contexte. Et là, avec ces contextes de pluralisme juridique, il nous prouve bien qu'il exerce son rôle. La question qu'il faut se poser maintenant est celle de savoir comment concrètement l'implémenter. Nous avons parlé de l'Afrique subsaharienne, il y a la question de l'analphabétisme, il y aura également la question de la volonté des autorités politiques et de la cascade de règles. S'agissant de l'Afrique de l'Ouest plus précisément, nous avons une communauté grecque qu'on appelle l'OADA. Il s'agira aussi de voir de quelle manière le guide juridique de l'agriculture contractuelle inspire les politiques publiques. Je vous remercie.
Merci, merci beaucoup. Samir, si je peux. The presentation, as you heard, was in French, but Samir understands English quite well. So if you have questions or for him in French or in English, you can of course pose to them. We did not prepare a translation, simultaneous translation, hoping that many could understand your presentation in any case, but it was focusing on the role of the informal sector and also customary law, which is taken into account in the legal guide on contract farming in various ways, even if perhaps the definition might be discussed, especially in areas such as formality, informality of the contract, and inclusion of certain participants and addressees in receiving information or being heard, and a solution of disputes, a resolution of disputes through autonomous third parties. But I will stop at that. And are there any questions or comments regarding this particular presentation at this point?
We have one more question in the Q&A, but perhaps we could move forward to the final presentation and then take the last questions.
Okay, let's do that because we don't have much time left, but we do have to give sufficient time to the last participants who took the fifth position, and is Berk Eker. He is an associate lecturer in law at the University of Wollongong and a PhD candidate at the University of Sydney Law School. And his doctoral research examines in particular human rights, due diligence, and the regulation of ultra-processed foods, developing an international legal framework for corporate accountability in the global food system. And he's also interested in other sectors such as biotechnology, intellectual property, and the governance of emerging technology. But he was interested in saying something about private law as well from his public law standpoint. So very happy to give you the floor on this topic: invisible partners, strengthening gender equality in agricultural contracting through the UNIDROIT FAO IFAD Legal Guide. Berk, you have the floor.
Thank you. So I'll try not to take too much of your time. The main reason I decided to write about this topic, particularly just looking at the guide and seeing what can be done to make more gender-specific provisions, was because a lot of my research in the ultra-processed foods area led to the understanding that the best way to combat ultra-processed foods, or a substantial way, is to protect small-scale producers, and that is a global issue. So when I was doing research and looking at contract farming, as well as the role that women play in farming and how they have a substantial portion of the workforce, yet they receive very little legal entitlements, it was natural that I just wanted to do my part in providing a modest critique of the guide based on just my own theoretical stuff. I don't know any of the practical realities of it. It's not my area, so please take what I'm saying with a pinch of salt. Now, regarding the main points of the guide, the main recommendations that I put forward in the essay, was that the first thing is that with negotiation and contract formation, the guide recognizes that producers often have weak negotiation power, but it could do more in defining the gender specific aspect of it. So rather than treating it as a general problem, being explicit about the gender specific constraints that systematically exclude women from negotiations altogether. So I utilized a bit of empirical evidence from Kenya and Mozambique, and I showed that without deliberate corrective measures, women remain invisible contractual actors. Now, I utilize international law as well. So Convention on the Elimination of Discrimination Against Women, butchered that. Forgive me, it's 12 right now at night. Brain's a bit foggy. But that's my first point. And now the second one is about access to resources, inputs, and finance. Now, this is just another issue with neutrality. So the research has shown that being more explicit about the issues that women face, or it is actually more conducive to ensuring that the recommendations or the things in the guide translate towards that issue. While gender neutral language does have a part to play, there are certain provisions that could be a bit more specific. So I just go in the essay, just go a bit more into depth and that sort of stuff. The last thing is dispute resolution and access to justice. So the guide does a great job in promoting alternative dispute resolution mechanisms, but again, there's gender-specific barriers that women face in accessing those mechanisms. they may be reluctant to use male-dominated grievance systems, they may face stigma or retaliation, or may lack mobility or information. So it's all about that gender-sensitive design framework, and that's essentially it. I know there's a bit more I could say regarding the key recommendations, but the overarching takeaway is that it is ideal to be very explicit and very specific about gender within the guide in order to tackle the issues on that front. And that's just what the research and the empirical evidence is saying. That's coming from a theoretical understanding. That's coming from just looking at the literature. That's coming from a bit of my contract law background, but that's it. So take that with a grain of salt. I don't know the practical realities of it all, but I hope that that could be a bit of a conducive starting point to maybe amend the guides in that direction. Thank you.
Thank you. Thank you very much, Berk, also for keeping the time so well, but being still very interesting in presenting the points of your essay. So we did have one question which was directed to the last, not to this one, but to the one before this one presentation. Merci et bravo. Est-ce que dans vos recherches, vous avez pu catégoriser quels sont les pays qui ont déjà adopté des lois grâce à la guide? Et perhaps Andrew, vous pouvez commenter, est-ce que vous pouvez le faire en anglais? Parce que je crois que la plupart des participants vont être dans la mesure de comprendre la réponse si la réponse va être en anglais. Andrew?
I think Samir, unfortunately,
Oh,
is
sorry,
not
I said
connected at the
Andrew, but
second.
it's I'm sorry, Andrew. It's really my fault. I made a mess of the names because I don't see your faces, but just the name. No, Andrew is a completely different person. So, but I meant Samir, but Samir is not online anymore.
No, I
Okay,
don't
so
see him. No.
right. So, but we have a Feline who would like perhaps to make a comment or a question.
Thank you so much, Anna. Yes, congratulations to everyone for your insightful presentations and, of course, for having secured these top positions in the competition. I had precisely a question for Monsieur Yerima. So,
but he's not here at the moment,
do you know
so
whether
probably
he's going to reconnect? Does he have connection issues or?
I am now in touch with him, but I also see that we have, meanwhile, another question for Berk.
Mm-hmm.
Perhaps we could allow this time.
So, Berk, there is a question which is online. Building on your findings that gender-neutral drafting is often insufficient, how can the UNIDROIT FAO IFAD legal guide be amended to include explicit, enforceable gender-specific provisions within agricultural contracts while remaining adaptable to diverse legal systems and practical realities across global food value chains? So, Berk, this is the question. Again, it would take a long time to respond, but
likewise, I agree. Well, in my essay, I do have some draft like examples of what could be included and where, but I think in order to answer your question fully, that's probably a whole PhD by itself to encapsulate all of the things in that system that interact. So I'm not comfortable answering beyond what I put in the essay, which is just some targeted amendments, but that's very conservative.
thank you very much. But the essays will be available, so there will be an initial answer at least in the essay. So, but we do have now Samir online. So fill in perhaps if you want to put your question, and then there was the other question online. Or perhaps we start with this one, which was Samir, dans vos recherches, vous avez pu catégoriser quels sont les pays qui ont déjà adopté des lois grâce à la guide. Et vous pouvez répondre en anglais ou bien en français. Peut-être en anglais, c'est plus facile pour les participants de comprendre mieux la réponse, mais vous pouvez choisir. Merci. Samir?
Vous m'entendez?
Oui? Yes? Not very well, I'm afraid. No. No, I don't think it's going to work. So if it allow Katerina, I think it's probably a good idea because we have gone a bit beyond the time at disposal, and it seems that there are some connections problems. So perhaps we do have Samir's contact. So perhaps we can, if with his indulgence, we can he can receive the question by fill-in as well, and answer as much as possible. So now, Katerina, I give you the floor again for the conclusions and
Thank you
Don.
very much. Thank you very much, Anna. Unfortunately, also Ignacio had to leave for the formal meeting to which he had a commitment at 2 p.m. sharp.
Yes.
So let me just also express my gratitude to all of you coming here today to join us to listen from all over the world, including both panelists and participants. And I will just pass the floor back to Don Wallace, who had the great opening of the session, also to close it and to have a final photo of the webinar.
And Katerina, if I may then after Don say something on behalf of Ignazio, because he told me that I should address the participants. Thank you.
Well, I don't have anything to add except to thank all the participants who were very impressive, and to thank UNIDROIT and to encourage it to continue this work, as I know it is doing in the agricultural sector generally, because it creates tremendous employment, participation in the society, and it feeds us. It's very important to be fed. So thank you all very much. And Anna?
Thank you very much to you, Don, for the support. This is really on behalf of everyone here, and hoping that this will continue also for next year. We would like, first of all, to congratulate all the participants and the winners for excellent essays. I must say I agree with the Secretary General that we learned a lot, because these contributions we get are more and more specialized and concrete. So it's an actual feedback on different areas, and I think all the contributions had that particular touch, even if they were different in nature. And we look forward to staying in touch with the authors, because, as you know, much will happen next year for the centenary. Professor Wallace knows that next year's essay competition will be even more important, because it will be the competition for the centenary, but we would like to keep in touch with the excellent participants of this year as well, and we will give you information of all the different events that will be organized because of the centenary of UNIDROIT. So thank you very much for your participation, also on behalf of the Secretary General. And thank you all. We hope to see you in person or virtually in other and to have other opportunities. And then I think Katerina will be in touch with you for a follow-up regarding your presentations and ways to make them better known. Thank you very much. And perhaps, Katerina, over to you. Do we close now the webinar?
Yes. Congratulations, the webinar is closed.
Thank you. Thank you very much. Bye-bye. Thank you. Bye.